Chairman, Judge, congratulations.
Thank you.
I want to try to understand the facts on some of these cases.
Yes, sir.
The Albertus Lewis case. He shot his girlfriend in the head. Is that correct?
Senator, as I stated, I'm not sure if you were in here earlier, that case is still pending. He's not been convicted of any of those charges. And so I have to be really careful in how I frame my question.
Did he shoot his girlfriend in the head?
Senator, based on, those are the allegations of the charge, yes.
So you're saying he didn't shoot his girlfriend in the head?
He has not been convicted of anything, is my understanding. And I know it's a very old case. It's 2017.
Well, when you granted him bond, did you think he had shot his girlfriend in the head? He was charged with shooting his girlfriend in the head, wasn't he?
Thank you, Senator.
You're welcome.
Those are the allegations. When he initially appeared before me,
okay,
I denied his bond based on everything.
Let me start over. Okay. Mr. Lewis was charged and arrested, so presumably there was probable cause, with shooting his girlfriend in the head and putting her body in a wheelchair and dumping her outside the hospital. Those were the allegations. Is that right?
I believe those were the allegations, yes.
Okay. And you gave Mr. Lewis bond. Is that right?
No, that's incorrect, Senator. I denied his bond. When he appeared before me in July of 2017.
So you didn't give him bond? He didn't release him?
I denied his bond. It was 2 years later.
Did you ultimately release him?
2 years later, after the state violated the court's order.
Did you grant his bond? I'm just trying to understand the facts.
Yes, sir. 2 years later, after the state.
You granted his bond?
When he initially appeared before me, I denied the bond. It was 2 years after that I granted a bond.
You did grant the bond?
After the violation by the state of the court order to try his case and discovery rules.
And then he went out and tried to kill 2 sheriff's deputies while using a baby as a human shield, allegedly. Is that right?
Those are the allegations in the other case, yes.
Okay. Would he been able to do that if you hadn't let him go?
Thank you, Senator.
You're welcome.
When he appeared before me, I denied his bond. He appeared before me again, at which point.
And you let him go?
The state violated the order of the court.
But I'm just
and I set a sufficiently high
You let him
bond.
go. If you hadn't have let him go, then he could not have tried to kill 2 sheriff's deputies using a child, as a human shield. Factually, is that correct?
I'm not sure, Senator.
Oh, I think you are. Let me ask you about Kelly Honeywell. You remember that name?
Senator, I did not have any involvement in that actual case, but I am familiar with what you're referring to.
Okay. You remember Troy Stevenson?
Yes.
All right. Troy Stevenson was arrested, allegedly, for shooting Kelly Honeywell, killing her, murdering her at a bakery. Mr. Honeywell was arrested. And Mr. Honeywell allegedly was a member of a gang. He owned guns, and he did drugs. Okay? You granted Mr. Stevenson bail. Is that right?
I didn't. In that case, I did not set bail bond in that case when he was charged with murder.
You didn't let him go?
I did not set the bond on the murder charge.
Who did?
I don't know who's.
How did he get out of jail?
Are you asking about the murder charge?
What I'm asking, and I think you know what I'm asking, Mr. Stevenson allegedly was arrested for shooting this bakery worker in the head, and he was granted bail. He was let out. You didn't grant the bail?
No, sir.
Who did?
My understanding is his bond was denied in that case on the murder case. Mr. Stevenson, I believe, after trial, was found not guilty of those charges. But I did not set the bond on the murder case. I did not try the case on the murder case. I did not set the bond on the murder case.
Okay. I think I'm out of time. Thanks, Judge.
All right, thank you.
Senator Lee.
Is that true?
Thank you very much, Judge Benjamin, for being here today.
Thank you.
Let's talk about your approach to reading statutes, to construing them. How much weight do you give to the plain meaning of the text of a statute when construing it?
Thank you, Senator. In considering a statute, the first thing that the court must consider is if it is clear and unambiguous. If it is clear and unambiguous, the analysis stops there. If it is not, I would then, the Supreme Court has said that it is appropriate at that point in time to consider the text once again, the principles of statutory construction, and also that it is appropriate at times to consider legislative history.
Okay. And when we talk about the plain meaning of statutory text, are we talking about the plain meaning as of the moment of enactment, or does the time in question and therefore the meaning of the text in question evolve based on changing social conventions, social norms, linguistic conventions, and so forth over time?
I believe that it's gaining an understanding at the time that it was adopted.
The time of enactment. Now, you were the judge assigned to a sentence reduction petition in a case called South Carolina versus Staten.
Yes, sir.
I hope I'm pronouncing that correctly. It's a case that involved a defendant who had been convicted of murder. He was serving a prison term sentence, a minimum mandatory term of 30 years. As I understand it, you decreased the sentence of the defendant to 28 years rather than 30 years, based on his some assistance that he had rendered to the police, to the Department of Corrections officer who was assigned to a case. You did this even though South Carolina's murder statute clearly states that no convicted defendant is eligible for parole or for early release or for good time credits of any kind under these circumstances. How did you decide that early release for that defendant was appropriate in spite of the statutory language?
Thank you, Senator. In considering that statute, I looked to the statute. I considered that statute was enacted after the mandatory minimum statutes. The statute specifically states that the motion can only be brought on the motion of the state or the prosecutor or the attorney general. That motion came before me on the motion of the state of South Carolina based on the Department of Corrections request for a reduction in the sentence. And I believe the captain of the Department of Corrections exact statement was that the defendant had unequivocally saved the lives of corrections officers. The title of the statute is titled Assistance to Law Enforcement or Department of Corrections. Our Supreme Court has stated that it is appropriate for courts to consider the fact that the statute, that the legislature was aware of other statutes at the time that they enacted the statute, and nowhere in the statute did it discuss mandatory minimums.
Is there any reference in that subsequently enacted statute that directly references crimes that carry those statutory minimums?
No, there was not.
Yeah, and that's what concerns me, is that the statute in question, the statute that I believe bound you, states, quote, no person sentenced to a mandatory minimum term of imprisonment for 30 years to life pursuant to this section is eligible for parole or any early release program, nor is the person eligible to receive any work credits, education credits, good conduct credits, or any other credits that would reduce the mandatory minimum term of imprisonment for 30 years to life required by this section. And so when there's a statute that's that clear, if there is then a subsequently enacted statute that makes no reference to a mandatory minimum sentence, seems to me to be a stretch to do this. and yet you've acknowledged that there's no reference to that statute. In other words, there's nothing that supersedes that.
No, Senator, the only thing that I can tell you is that in that statute, that the substantial assistance to law enforcement statute, the General Assembly gave great deference to the prosecutors in the state and also to the Attorney General to bring the motion. That motion cannot be brought by anyone else. It was brought to me based on the motion of the state of South Carolina to reduce the sentence based on the substantial assistance. The case law in South Carolina says that our Supreme Court has instructed trial judges to assume that the General Assembly was aware of the subsequent statute at the time that they enacted the new statute, which would have been the substantial assistance statute.
Okay. I see my time's expired. Thank you, Judge.
Thank you.